Today's broadcast is brought to you in part by Corporate Capital Direct. Listen, banks are not lending, and the online lenders may not tell you all you need to hear to make the right decision for your company needs. Get the inside edge for business financing. Whether you have capital needs for inventory, payroll, general operating expenses, or even to consolidate expensive debt or tax issues, Corporate Capital Direct can help you avoid common mistakes when seeking a capital solution for your business. Never upfront fees. Get the inside edge for your business financing needs. Call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com. Again, call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com.
Welcome to Legal News and Review, recipient of the Florida Bar Award of Excellence, and featuring Michael Santucci, co-chair of the Intellectual Property Division of the Broward Bar. From the law firm of Santucci Priori, practicing intellectual property, business, and entertainment law and litigation, located in downtown Fort Lauderdale. Legal News and Review, the only real problem solver radio program using the law, with your moderator, Philip Bell, and hosts and legal panel attorney, Gary Singer, chair of the Broward County Bar Association's Real Property Section. Gary Singer is board certified in real estate law and a syndicated columnist from the Sun Sentinel. He is an expert in his field of practice. Now, here's your moderator, Philip Bell.
On the docket for today's broadcast, Governor Rick Scott receives Senate Bill 590. The bill is a presumptive time-sharing schedule for Florida's children and family. The Florida Bar opposes this bill that could be signed into law by the 20th of June. Today, from the law firm of Brinkley Morgan, we have board-certified in-family law attorney Kim Nutter, who will be giving us the 411 on this bill and why the Florida Bar is against it. And also, she'll be educating us on collaborative law, where Florida is now the 15th state in the nation to adopt a version of the Collaborative Law Process Act. First, I'd like to welcome and, of course, introduce our legal panel host. Good afternoon, Michael Santucci.
Hi, Phil. I think Governor Scott owes us a visit to our show. You start out probably a quarter of our shows out with his name, right?
Yeah, that's true. You know, he keeps things secret, and then all of a sudden they pop up. But that is true. And, of course, least but not less, Gary Ostrow. Good afternoon.
You pronounced my name right, Phil.
That's, I did.
That's good. I appreciate that. Thank you.
Yep. And Gary Singer will be back next week. Kim Nutter, Legal News and Review, feels there's Nutter better than you. To explain this Bill 590, good afternoon and welcome.
Good afternoon. Thank you so much.
Kim, in all seriousness, which this is a serious issue, Senate Bill 590, which has the presumptive time-sharing schedule for Florida's children. To me, it sounds like, hey, that could be a good idea. Keep it out of the judge's hands as well.
It sounds good, but 590 is limited. It's not just for all family law cases, and that's part of the problem. 590 is primarily for the Department of Revenue type of cases.
Right.
And normally the Department of Revenue handles just child support cases. So now this law, if passed, if the governor signs it, will basically allow the Department of Revenue and an administrative law judge, which is slightly different than a circuit judge who is in family law, to put before the parties a parenting plan. And this parenting plan, instead of being a general parenting plan, and instead of looking at the normal 20 factors that the court is supposed to look at,
right,
deciding a time-sharing parenting plan, it is going to have a presumption built right into it for a time-sharing plan. And it is not a 50-50 presumption. At the moment, it looks like a 70-30 time-sharing presumption. So the people who receive this are, unfortunately, for the most part, unrepresented. And we fear that they will not know to ask the questions. There is a presumption that they are supposed to accept this and simply sign a parenting plan that has this built-in presumption.
But Kim Nutter, Laura Davis-Smith, who chairs the family law section, when you say we, you're talking about the Florida Bar. You're not just talking about, we as us sitting here.
I'm talking about the family law section of
Yes.
the Florida Bar.
Florida
Correct.
Bar.
If I can jump in, Gary Ostrow, I'm very familiar with this collaborative family law. Kidding.
He's joking.
But I'm becoming, and 70-30 in favor of who?
The collaborative law is different from the Senate Bill 590.
No, I know, but
Okay.
the 70-30 you just referred to is in favor of who?
The 70 would be in favor of what you would call we don't use the primary parent anymore, but the parent who the child is going to be with most of the time.
So, in other words, they make that determination, and then there's no negotiation. It's 70 for that person and 30 for the other. Non-negotiable?
Oh, presumption, right?
Correct.
Yeah.
Oh, okay. That puts it in perspective.
I mean, this is Michael Santucci. The ongoing debate there is, is it better to have? I'm trying to say this without showing my bias, or my opinion. But is it better to have politicians and bureaucrats making these decisions, or the local judge sitting there in the community? And we have that issue in criminal law with sentencing guidelines that Gary deals with all the time. Do you want the local judge making these decisions, or do you want some kind of the decision made at some macro level? And I've heard good arguments for both sides.
The problem with this presumption is it completely disregards the statute. Mm-hmm. You're not looking at the 20 factors at all.
Gotcha. Yeah.
And the parties themselves often are not educated enough to know that those are the factors to be considered.
So what's the driving force behind this, and what's motivating the driving force behind this? What's the idea behind it? Who benefits? And we follow the money trail, or what do we follow to figure out where this is coming from and why?
I think from a principal way, under the Florida statute, in order for child support to be determined, you're supposed to base it on a time-sharing schedule. And so normally in a family court situation, you would be looking at a various time-sharing schedule. And once that time-sharing schedule is determined, you then look at what a child support would be. So if you look back and see that normally the Department of Revenue, which brings cases for child support if somebody has come before them and they are seeking to have some kind of financial assistance from the state, that is normally when the Department of Revenue would get involved and want to pursue obtaining child support for those children. So what they've been doing is making child support determinations without first determining time sharing. So I think it's a catch.
Yeah. It sounds like backwards to me. It sounds like they're taking a huge step backwards. Where is this coming from, and whose idea was it? So we can conspire to have them killed. I mean, no. I'm going a little bit far.
Well, I'll tell you.
Where is this coming from?
Laura Davis-Smith, that chairs the family law section, sent out emails and information, and I have one right here, that she's encouraging people, it doesn't matter if you're a lawyer, anybody that feels strong enough to have this bill not become signed into law, you can actually call and urge the governor not to sign this Senate Bill 590. You could reach the governor at area code 850-488-7146. And to answer your question, I think it has to do with keeping it away from the judge, meaning that you sign a parenting plan and a payment schedule, and then you get the timeshare schedule, so that way the judge is out of the play.
Less discretion?
But the problem is, this is an administrative law judge. It is not a circuit judge sitting in the family court.
Very good
so
point.
Even if a presumptive time-sharing schedule is signed, when somebody goes to enforce it, they're not going back to that administrative law judge. They suddenly have to bring that action and file an action in the circuit court and appear before a family court for the first time. So even whatever it is they're trying to resolve, our family law section's belief is that it's becoming much more muddled, and it's really not obtaining whatever the goal here is.
But that's the point. What is the stated goal? Do you know what the stated goal is? Because if it's to unburden or reduce the docket, the level of litigation on the docket before a circuit court judge, like you said, it goes back to the judge under certain circumstances anyway.
Different judge.
Different judge.
Different judge.
You know, Gary, that's actually a good segue, because
good word.
Keeping it out of courts on March 24th, 2016, Governor Rick Scott, I invoked his name again, Michael Santucci, signed into law the Collaborative Law Process Act, making Florida the 15th state in the U.S. to adopt such a law. The act recognizes established requirements for the use of collaborative law process, and it's so refreshing to hear a litigator, somebody that's board certified. You can't be board certified without having so much trial experience, who is so
super
for
lawyer,
this.
Super lawyer, AV rated.
Yeah.
Yeah, put that in there too.
That's right, she is. I'm actually a big fan of Kim. But this process, what actually is collaborative law?
Collaborative law is an organized process. It involves 3 disciplines. If you look at it from the application of family law,
Right.
it involves 3 disciplines. Each party has their own attorney. You have somebody that is normally a mental health professional. We call them the collaborative neutral facilitator. And if need be, you have a neutral financial person, a forensic accountant.
I see.
Okay, so the 3 disciplines work together as opposed to fighting each other. They work together through a very organized process that still allows for confidentiality. It still allows for advocacy. It still allows for full financial disclosure, and in my opinion, more financial disclosure at a faster speed. The reason that it's so organized is there are agendas. The meetings are limited to 2 hours. You're not in one of these 10, 12-hour mediations that we litigators have been far involved in far too often when you have exhausted clients and you're not sure they're really thinking straight by the end of the day. And it's very systematic. It allows people who go through the difficulty of divorce,
Right.
particularly with children, to hopefully come out in a much more dignified manner, and more importantly, when it comes to children, to be able to co-parent, to raise those children together, because litigation destroys the relationships between the parents and puts amazing hurdles in the ability to co-parent afterwards.
Sure, that old adage, you see the best people at the worst time.
We certainly do.
Kim must be an advocate for collaborative law. I just read on your firm's website that you actually teach and lead 2 complimentary seminars for the mental health professionals that participate in the collaborative law process.
Our firm has done that for years. We give 2 free seminars, one to mental health professionals where we talk about all forms of law and try to assist in that, and another one we give for financial people to talk to them, again, cutting edge issues and to bring these issues to the forefront.
But as a litigator, which you're well known for, you embrace this. You want to keep it out of the court, but other attorneys I spoke to about it, they feel that, they're taking a pay cut if they do this. But it's the best interest for their client. I mean, I'm being honest. Everyone's shaking their head saying, yeah.
Are you taking a pay cut? In one way, you're taking a pay cut per case, but you're hopefully going through more cases and helping more families. If you're in a litigated case, and I'm sitting here with 2 well-known litigators,
Right.
We all know what the court system does. We all know when you want that motion, how long it takes to get before the court, and therefore how long whatever limited relief is that you're getting. So the court is a very difficult process. They've had amazing budget cuts and all kinds of problems, and it is a process that is full with rules and blocks really the ability to focus on the children or focus on the ability of families to move through a process.
Kim, Gary Ostrow, I think it's incumbent upon the lawyers that litigate these type of cases to adjust. And it's not about, even if it would prejudice me as a lawyer, like if they legalize certain drugs, and I hear lawyers complain about that do criminal work, how it might impact their pocketbook. It's not about us and how we might impact it. It's about public policy and what's best for the litigants and the families and the kids. And if it does change up the hours somebody can bill, well, they can make an adjustment. That's what I would do. I believe in what's best for everybody as a whole. And I think it's very selfish for lawyers to be thinking, well, I'm not going to be able to bill as much. And they can, if they're creative and they're really good at what they do and they really care about their clients, they'll make it up one way or the other, whether it's volume or another way. So I think that should be the criteria. It's not, but I think it should be.
I certainly agree with you, and there is one component of collaborative law that I found great resistance with lawyers on, and that is if for whatever reason the collaborative process doesn't work, it breaks down. You cannot bring it to a conclusion. And at that point, somebody says, I am done. I'm going back to the court system. Everybody has to get new attorneys.
Why?
It was ingrained in the creation of the collaborative process. Think about it from the standpoint of family law. You want to stop the knee-jerk reaction. And so one officer has to have a reality test of, I've just engaged how much time and how much money. And if the process is breaking down because I'm frustrated, I'm angry, I'm becoming emotional for whatever reason, let me bring myself in check, which is also part of the reason that you have this collaborative neutral who is the mental health facilitator to not only help keep emotions and people focused, but sometimes to keep the litigators in line who forget that have done the paradigm shift.
But it's a disincentive, I guess, for the litigants to
That's the idea.
To walk from the process. So.
That is the idea.
Good point. It forces their hand to get it done.
Correct.
But money does change in relationships, will contests, because Collaborative Law Process Act has more than just family law. Is that correct?
Yes. Right now, the focus is family law, but throughout this country and internationally, collaborative law process is used for any type of personal disputes, such as probate litigations, will contests, those kinds of issues. They have that in Italy, and I understand it's quite successful. So hopefully we will, grow into that.
Yeah.
If I can ask, who benefits the most from this being implemented on a huge scale? You had to define a role in the system, somebody, whether it's administrative judge or otherwise, who benefits the most? And I'll ask financially, who's going to be most benefiting from this spreading out?
Financially, it's going to be the families.
Why?
Because they are going to be able to, even though you have all of these professionals involved, it is going to be a system that allows them to move through this process faster without going into court and wasting time, waiting for those hearings, sitting outside the court hearing, not having your hearing completed, waiting 2 more months to get that extra hour that we know is an unfortunate process.
It's also a savings for the taxpayer. It's less
That's a good
stress
point,
on
too.
the court system.
Correct.
But T. Boone Pickens, you could Google this. T. Boone Pickens Collaborative Divorce claims it saved him millions of dollars. Plus, guys, collaborative divorce, in the most part, is confidential.
Yes, and that's a huge issue. You're not in the court system. You're not in the open docket. You don't, there are people who go and look at the docket to see who has filed. You're behind closed doors. At the end of the day, you hopefully have reached a settlement, and the only thing you then do is go in for a simple, uncontested final hearing.
Right.
And then certain courts we can work with and not file marital settlement agreements sometimes, not file certain things to keep it even more private.
But you've handled some very complex divorces. Of course, we're not going to talk about personal information, client-attorney privileges, but you had an interesting case regarding Bitcoins.
Yes, I
Bitcoins.
did.
You guys know what Bitcoins are?
Yes. The people that bought them early on are doing really well right now.
Yeah.
Yes, very on. Yes, except for it took a big plunge between Sunday and today.
Did it? Go. So you're watching it.
Yes. Yes.
Did it actually take a forensic accountant to find this out? How did you find out about Bitcoins in this marital assets?
No, I've actually introduced Bitcoin to forensic accountants and asked them to become more aware of it. I became aware of it because of a case that I had in which that was a major asset of the estate. And all of a sudden, I had, frankly, always known a little bit about it, found it a little interesting.
Right.
And then because of that case, I obviously had to delve into it considerably more.
And are you talking about 7 figures type of a case?
It was at least 6.
Okay. That's still substantial as well. We're going to take a quick station identification and break. You're listening to Legal News and Review on 96.9, 103.9, 740 AM, as well as nationally iHeart, TuneIn, and iRadio Now. And we're speaking with Kim Nutter, and I'm not joking. There's no Nutter better than you. I mean that.
You cannot resist.
Yeah. And we're talking about collaborative divorce. It is a growing, I don't want to call it a trend anymore. It's a respected process that attorneys are embracing and bringing it, the good attorneys are bringing it to their clients' attention as a viable alternative, because collaborative is just that. Let's work together to make this the best we can. We're going to be right back.
Today's broadcast is brought to you in part by Corporate Capital Direct. Listen, banks are not lending, and the online lenders may not tell you all you need to hear to make the right decision for your company needs. Get the inside edge for business financing. Whether you have capital needs for inventory, payroll, general operating expenses, or even to consolidate expensive debt or tax issues, Corporate Capital Direct can help you avoid common mistakes when seeking a capital solution for your business. Never upfront fees. Get the inside edge for your business financing needs. Call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com. Again, call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com.
Welcome back to Legal News and Review. Recipient of the Award of Excellence from the Florida Bar, featuring Michael Santucci of the law firm Santucci Priori, practicing intellectual property, business, and entertainment law and litigation, located in downtown Fort Lauderdale. Reach them at 500law.com or 954-351-7474. To contact the legal panel hosts and guests, go online to belegalbuzz.com. Once again, here's your moderator, Philip Bell.
Legal News and Review is back on the air. I'm with our legal panel host, Michael Santucci, and Gary Ostrow. Gary Singer will be back next week. And today, from the law firm of Brinkley Morgan, we have board-certified in family law attorney Kim Nutter. And being board-certified makes you an expert, and I could legally call you an expert, you know? And that's a real privilege to have and to be able to say, sincerely. And so far, you have not let us down. You've answered all our questions, and it's been very enlightening as well. When it comes to collaborative law, especially yourself that, you know, embraces this technique. And it is a technique. And it's in the best interest, I think, of both parties financially, but even more so kids. Because kids are the quiet victims. They're the ones that,
absolutely,
you know, have to live with this in these decisions. And we were talking about Senate Bill 590, and the bill is a presumptive time-sharing schedule for Florida's children. And apparently the family law section is against that bill.
That's correct.
And they want everybody who's listening to please contact Governor Rick Scott and let them know, please don't have this bill signed as well. But when collaborative divorce is initiated, there is a pitfall. And that pitfall is what happens if an agreement is not reached in collaborative law.
Well, it's more of a what happens if the process breaks down. And that means people have chosen to no longer participate and then resort to the litigation system. And if that were to happen under the process and the principles, then the attorneys cannot be the attorneys who represent the parties in litigation.
Can it be as similar to a traditional divorce where you can have modifications in a collaborative settlement?
Oh, absolutely. It does not. This is not limited to initial divorces. If someone has to modify, whether it's a time-sharing modification or a support modification, you can absolutely and encourage to go back and participate in a collaborative process.
And the process could work, depending on the complexities, as quickly as 90 days. Is that correct?
Yes, that would be a very one with little simpler issues, but absolutely. It's not just you have to start the process. I have been involved in cases which I'm not quite sure, my client's not quite sure if the collaborative process will work. We may start an initial divorce proceeding. Luckily, I've had an ability to then abate that proceeding, to then turn around and participate in a collaborative law process successfully.
We only have 2 minutes left, and I have to ask you this question. Are we going to have alimony reform at any point in Florida?
Well, considering that has been a hot topic and has occupied the Family Law Section's Legislative Committee for a good 4 years, and given what happened this year, I predict it will be back next year in some form or another, at least the issue of it.
Yeah, I mean, Illinois got their act together. They have an alimony reform that seems to be working as well. I wish we had more time to even talk about pets, because in Alaska, pets are no longer property. They're actually like a member of your family when it comes to divorce issues. You have such a fine firm, Brinkley Morgan, sincerely. It's so well known, and a large firm, too.
Yes.
If somebody has questions regarding collaborative law or collaborative divorce or anything along the lines, even guardianship, What is the best way to contact you?
Well, through the firm, BrinkleyMorgan.com. We have 3 offices, but through that, they can easily reach me or one of my wonderful partners who are also qualified investigators.
Wow. You know, we definitely like to have you come on again and possibly even filling in as a legal panel host. You did such a great job. You were able to fend off Gary Ostrow. You know?
Imagine that.
That's a scary thing. I have to work with him.
No easy task.
Yeah. Mike?
Well, Phil, Kim is also a certified mediator, family law mediator as well. So for any attorneys out there that would like to contact her, the same contact information.
When do you sleep at night?
Right.
My goodness.
That's a waste.
Sleep's overrated. Gotcha.
Well, I want to thank everybody. I want to thank my co-hosts, criminal attorney Gary Ostrow, Philip Bell, and also Kim Nutter, our special guest today. Please email me. I'd like to hear what you think of our show or any suggestions of what you want to hear more of or hear less of. Email info@500law.com. That's info@500law.com.
And where can they find past shows?
Yes, and you can go to 500law.com and go to Listen to Us Daily. And you can get all of our past shows there and listen to them on the website, 500law.com. So, everybody, if you're in a car, please put your phone down. Don't be tempted. Listen to the radio. You're almost where you're getting. So, remember, everybody,
Be legal!
You've been listening to the award-winning Legal News and Review, recognized by the Florida Bar's Award of Excellence. Legal News and Review, featuring Michael Santucci from the law firm of Santucci Priori, located in downtown Fort Lauderdale, and practicing intellectual property, business, and entertainment law and litigation. They can be reached at 500law.com or at 954-351-7474. To contact the legal panel hosts and guests, go to BeLegalBuzz.com. And to reach Gary Singer, board-certified real estate and syndicated columnist, appearing in 400 media outlets, including the front page of the Money section every Monday in the Sun Sentinel, from the law firm of Gary M. Singer, PA, call 954-851-1448 for legal news and review. Remember, be legal.